actually in a little folder like this, and there may well be, like tab 3 or 4, may only be necessary if a particular answer demands that. If you get an admission early on, and sometimes you do see the other thing you see with American lawyers, this is you see that they know that they've got an admission that renders a whole chunk of their outline unnecessary. I try not to do the visual, I just do it with the tabs. So that's the backstage question. You can.
Is that giving some message to the witness?
Yeah, you don't want to have.
Maybe it's maybe a misleading message, possibly.
Well, I too have a cross outline, although it's not my preferred technique, and I'll tell you why in a moment, as well as annotated copies of the witness statement, the exhibits, and what I referred to as the statement of facts, although I was hoping that I wouldn't have to really invoke it too much because it wasn't clear to me what its legal status was here. If you can see my cross outline, you'll see why I don't like it very much, because it's covered with red ink, and it's covered with black ink, and it's covered with arrows, as I tend to refine these things. And I was trained by the former chairman of our firm, who I thought had a wonderful technique to organize cross, and if time and, frankly, Larry were paying my bill, I would have done it that way, to prepare cross with an issue orientation. He would always use blue sheets. He literally would have the cross outline broken down by issues. And of course, when I say he, I would say his juniors. He would simply work off it at trial on blue sheets. Why? So that he can immediately identify them in all of the paper on the table. He knows exactly what he's dealing with. And to each issue, if it's short enough, he would insist, and I insist typically, that I would have the key documents stapled to the blue sheets so that I can mark the documents, I can make annotations as to where the pieces fit together, and then I would put them in a notebook. But I would put them in a notebook so that if the witness stumbles into a new area, I can go from the front of the notebook to the back and take out that issue and go through that part of the examination. And at each break, sort of make an evaluation. What were my key issues that I'm now running short on time on? What can I afford to jettison by issue, and what do I have to carry on with?
Do you ever write any questions out for key sensitive areas that
Well, I mean, my outline was 20 pages, so I wrote out more questions than I would have liked. But again, it was a question of preparing for this particular thing under the time constraints. I prefer to have an outline just to be able to, I think it's more credible. I hate when I'm sitting on the tribunal to have a lawyer sit there and read questions. I mean, most of them are astute enough to make it seem as though they're not reading them. But, you know, I was reading a lot of my examination today.
But you'd be amazed. No matter how many times you write out the questions and rehearse them and talk them with your colleagues, it's amazing how many times when you're actually asking the question and you look at the next one that you've written, you say to yourself, that's totally stupid to ask that. Or actually, it makes no sense to ask that because there's a lot of things you realize in the moment. So it's very dangerous to slavishly adhere to an outline. And it's also very, very important. And live note, I'll get to live note in a sec. It's obviously important that it's often ignored to listen to the answer, because you write out an outline saying, I'm going to get a yes-no answer. But so often, an answer is more than just yes-no. And we're always told to anticipate the bad answer. That's why you're trying to get yes-no. But so often, there's a good little nugget in their answer that you need to exploit in the moment. So don't be...
Or park for later.
Yeah. And the live note, live note is a live transmission of the questions and answers. That's enormously effective in terms of picking up those nuggets, as long as, again, you don't become just slave to the machine. You benefit immensely from looking at the witness while they're giving their answers, I think.
But you have the ability with live note to make notes of the actual language used.
Yes.
And that means that you can question the witness on it, and the witness cannot escape from that. Any other thoughts, George?
Well, I'd say two things about the outlines, and I totally agree that I think certainly when I was a younger lawyer, and you see younger lawyers, they tend to have an outline which they march through very methodically. And that's maybe the right thing to do, because they've thought it through, they've consulted with their peers, they've talked to their own expert if it's an expert cross. So they don't, it's much safer to do that. But as you get more experienced and you listen, you look for opportunities and you change gears and you seize the moment and you don't get slavishly adhere to the outline. The other thing I'll say is I do detailed outlines, which, as I mentioned earlier, have 5 times as much material as I'm actually going to use. And I find, Steve, that this is just a mechanical thing, but I used to write them out, but now I type them, because then I can make all the edits and changes and so on, and I can highlight things that are really important. And then the other thing that I think is important is where you start and where you finish. So I always have one line that I want to have at the end. And the other point about that is I make sure I get to it, because if you're marching methodically through an outline and you've got this absolute gem that you want to get across at the very end and you run out of time, that's a huge missed opportunity. So, it's really important to have in mind one thing you want to absolutely establish and make sure you do that before you're finished.
How important is it to end on a high note? I mean, I think frequently the questioning ends up with, may I have a few minutes from the tribunal? I want to check my notes to see whether there's anything else I want to ask. That's because I think many people, probably justifiably, have concern that they leave something out that they wanted to ask. I mean, do you guys here feel that a high note is important at the end? Or?
Certainly that's the goal. That's always the goal. But, we're always working in teams, and it's almost inevitable that the other members of the team will suggest things that were missed, and that break is really to kind of hash out, is it important enough to kind of break the momentum and go back, or was it just an add-in? And depends is the answer, I guess.
In real life, not every cross-examination has a nice bow tied at the end of it, because if I'm cross-examining a metallurgical expert, right, there's going to be a lot of lunesta movements in that. That's a sleeping pill in the United States, and the chances of me wrapping that up with a real zinger at the end are pretty minimal. However, when you are dealing with, two things. One is when you're dealing with a CEO witness, there's a little bit more importance in the end of it, because if nothing else, you want an impression, if nothing else. The other thing is, it gets back to what Ben was saying earlier today. If in doubt, be brief. Because the one way you will guarantee you will not have a high note is asking the one question too many.
George, did you say you want to start out with a high note too?
I like to start on something interesting. It doesn't necessarily have to be a high note, but now we had a discussion earlier about whether you start out with your impeachment right out of the box. And
yeah, and I think the author of that is here, and he kind of disavowed it when we were standing outside.
Right, and I'm more in the Tim camp, and Steve, you did this too, of establishing sort of the foundational facts, getting them on the record, getting the admissions you need, and then going to the inconsistencies.
I would, if this was an expert, and the expert had testified, say, in American litigation before, and I've had this before, and an American judge or an English judge had written an opinion that said this expert is biased, incompetent, a shill, I would get that out early. So it depends on, but that's a very different thing. This is a CEO that outwardly is respectable. I think she'd need to be cooked a little slowly. With an expert who if you let them talk for an hour and they sound like a very wise person, the revelation at the end of a very erudite expert's presentation that some judge in Oklahoma didn't think they were up to much might not have the same impact as hitting them at the beginning. So it really depends on the...
I had a criminal case quite a while ago in which I asked the defendant about his date of birth at the beginning. And it turned out that in prior testimony he had given, I think, 4 different dates of birth. So this was either a compulsive liar who liked to sort of, or just forgetful or reckless. But it certainly established that the unreliability of the present testimony if he couldn't get his birth date straight at an earlier time. He also happened to be the defendant in this criminal case. Any other questions from out here? Okay, I think we're finished. Thank you all for coming and participating. We have drinks outside, Prosecco, and some good things to eat. So we can all give ourselves a pat in the back and some applause.
Thank you. And Mike is going to thank you. Thank you.
Well, thank you. Hard work. Both of you guys put the effort in. It wasn't easy. You paid me off. I'm paying you back for giving me that committee.
It's interesting. I mean, it was interesting to see the two styles when you were saying what's done there. Interesting to see the two different styles. And they were different.
I was there for 3 years.
And that was very good. Yeah.
Oh, really? What's that? We give out honors when people win honors? Way honors? What is that?
Sycamore has these medals and stuff.
Oh, yeah?